Good morning or afternoon, everyone, depending on where you're located, and welcome to the PACE ConnectFirst TCPA webinar series part 2. My name is Chris Herrick, and I'm the SVP of PACE and will be your moderator on today's call. As we do get ready to begin, there's just a couple of housekeeping items that I would like to inform you all of. First of all, the webinar is being recorded. Secondly, all of your lines are on mute to avoid background noise. Now, we will be taking questions at the end of today's presentations. So if you have a question, please be sure to type it in the question chat box in the lower part of your screen, and we will get to as many questions as possible. So without further ado, I'd like to go ahead and introduce our speakers for today's webinar. First, we have Nick Whisler, and Nick is a partner at the law firm of MacMurray, Peterson, and Shuster. Nick's practice focuses on assisting clients in all verticals understand and comply with the federal and state consumer protection, advertising, privacy, and telemarketing laws and regulations, including the Telephone Consumer Protection Act. Nick is also accredited as a certified information privacy professional through the International Association of Privacy Professionals. Our next speaker that we have is Ryan Thurman, and Ryan is the Sales and Marketing Director with Contact Center Compliance with over 15 years of experience in the contact center industry. Ryan is recognized as a compliance industry expert with a focus on state and federal marketing and privacy regulations, including the TCPA, FTC, state and global compliance regulations. He also serves as the regulatory chair of the West Coast chapter of PACE. And last but certainly not least, we have Geoff Mina. And Geoff leads the company's strategic direction and is also the primary architect of the ConnectFirst platform. He has taken the product through 4 generations in a desire to develop the most feature-rich, highly scalable, fault-tolerant, and secure cloud-based contact center solution on the market. Geoff has over 15 years of experience in the cloud telecommunications space. Now, our agenda for today is Nick is going to give us an update on the TCPA. Then Ryan Thurman will give us some data compliance tips regarding the TCPA. And then, Geoff will talk about TCPA Safe Mode, and then we will go into our Q&A section. So right now, I'm going to go ahead and turn the webinar over to Nick to kick off with a TCPA update. Nick?
Thanks, Chris, and thanks everybody for attending today. What I wanted to talk about today was number one, an update on the automatic telephone dialing system issue. There's been some case law that's come out since the FCC ruling back in July that was covered during part 1 of the webinar. And then secondly, to discuss the TCPA consent requirements if you are going to be using an ATDS to make calls. So with that in mind, I thought we'd just take one step back and lay a little bit of groundwork here, just kind of provide some context for the things that we're going to be talking about today. So really what it all comes down to is that the TCPA requires entities that are making calls using an ATDS, an automatic telephone dialing system, or a pre-recorded message to have prior consent for such calls. And as of 2013, there are now 2 different standards. If it's a non-marketing call, you need prior express consent. And if it's a marketing call or an advertising call, you need prior express written consent. So we'll talk a little bit about what those terms mean and how the courts have been applying those terms. As far as right now, I think the one thing that I always stress whenever I talk to people about marketing versus non-marketing calls is that a dual-purpose call is considered a marketing call and therefore subject to the written consent requirement. So we get lots of questions from lots of different people about why are you considering this to be a marketing call? Isn't this an informational call? Isn't this a customer service call? But the problem is they have some type of upsell component in that. So just know that if there's any type of sales presentation or promotion for a future sale, even if it's not during that call, that it is a marketing call subject to the written consent requirements. Importantly, though, the consent requirements don't apply if you're not using an ATDS or pre-recorded message to make that call. So really what we're trying to analyze is the type of equipment used to make the call, number one, and then number two, if an ATDS or pre-recorded message is used, the type of consent required to make that call. Last, I just want to mention another common misconception is that the requirements don't apply to B2B calls. They do. So if you're calling cell phones, it doesn't matter if it's a business cell phone or an individual consumer cell phone, it is subject to the same requirements. Next slide, Chris. So with that in mind, we're going to talk a little bit about the definition of ATDS. I think most of you are familiar with this, but as a refresher, the statutory definition is equipment that has the capacity to A, store or produce telephone numbers to be called using a random or sequential number generator, and then B, to dial such numbers. So it's pretty narrow. It does have the word capacity in there, which has caused lots of problems and issues, as we'll see. But it is pretty limited in terms of what that capacity is. It's storing or producing numbers using a random or sequential number generator. The problem, though, is that the FCC, dating back to 2003, has held that a predictive dialer or any other type of equipment that can dial without human intervention constitutes an ATDS. So that's kind of some background to where we were at coming into this year. Next slide. So the ruling back in July, which I have no doubt that most of you have heard about via articles, multiple webinars, maybe some live events that you've attended, but again, as another refresher, basically what they said is that when you're looking at the capacity of a dialing system, you can't just look at what it can and can't do today, its present capacity. You also have to look at the potential capacity or potential ability of that system. And so what they meant by that is that a system might be an ATDS even if it requires some type of modification, including a software download, some type of system update, unlocking a hidden feature. Those are all items that they specifically referenced in their ruling. So something might be an ATDS even if it needs to be modified. They tried to draw a line, though, short of making everything an ATDS by saying that if it's just a mere theoretical ability to modify something to have these functionalities, that's not sufficient to make it an ATDS. Now, the problem is they didn't really do a good job of delineating between what's potential capacity, what's theoretical capacity. We kind of have to try to draw that line ourselves. It's a difficult thing to do, but certainly something that we've been working on over the past few months with various different clients. Next slide, Chris. So after the FCC ruling came out, there have been a limited amount of case law. Chris, you can go ahead. So next slide, please. There has been a limited amount of case law applying the ruling to a specific dialer or a specific system used to make calls or send texts. The two most notable ones both came out of the Northern District of California. First is this Luna versus Shaq case, and basically what the court held is that the system has to have the ability to dial without human intervention to be an ATDS. So that was the standard prior to the FCC ruling. They continued to go back to that standard. It did reference the FCC ruling, but it didn't really discuss potential capacity at all. It's just completely ignored. And I think the primary reason for that is probably the fact that the parties had submitted their briefs prior to the FCC ruling. So they were arguing over whether or not the system did or didn't require human intervention, and that was the focus of their briefs. After those were submitted to the court, the FCC and the plaintiff tried to then point to a potential capacity standard, and the court just kind of ignored it. So procedurally, it's kind of interesting because most of the arguments were submitted before the FCC ruling, so I think that's probably why they completely ignored it. But fortunately, next slide, Chris. Fortunately, they did address that specifically in another case. So last month in Derby versus AOL, same court was once again analyzing whether a system that was used to send text messages was an ATDS. And the court said that it took a really narrow reading of the FCC ruling and said all it really meant is that a system that requires modification may fall within the scope of the TCPA. It does not mean, though, that a system that never operates without human intervention is an ATDS under the statutes, and it didn't negate the prior court rulings that focused on the capacity to dial without human intervention. So it's kind of interesting. I mean, the ruling is so ambiguous, and the FCC did such a poor job of outlining what the standard is. At one point, they talk about random or sequential number generation. Another point, they talk about dialing with human intervention. Another point, they talk about dialing randomly or sequentially. So there's kind of different standards that they keep talking about, and I think what the court here did was just kind of pick the language that it wanted to, which was the human intervention language, and say, look, it even says right here that the basic capacity of a dialer, of an ATDS, is to dial without human intervention and to dial thousands of numbers in a short period of time. It cherry-picked that language to reach its conclusion that the system wasn't an ATDS. So great case. It did defer to the FCC on the predictive dialer ruling, but it was basically saying that this system here is not a predictive dialer and it doesn't operate like a predictive dialer, and here are all the reasons why. So overall, really good ruling. It'd be interesting to see how other courts ultimately address that issue. I think that one of the interesting things about how this is going to play out relates to the Hobbs Act, and basically the Hobbs Act says that district courts have to defer to the FCC when it comes to TCPA rulings, and you saw that in the past. All these courts were saying, well, the FCC held a predictive dialer is an ATDS, so therefore it is. Even if we don't like that result, we're bound by that. We have to follow that. I think it was just kind of pretty much black and white there. Here, when we're talking about this potential capacity standard, I think it's so unclear and ambiguous that the court can kind of do what the court in Derby did, which is, okay, which part of the ruling are we going to point to reach the result that we think is correct? And so, and this court really honed in on that human intervention standard. Another court might really focus on potential capacity. It remains to be seen. So I think kind of keeping an eye on this and monitoring these cases as they continue to come out is going to be very, very important, and something that you certainly want to pay attention to, and that pace, I'm sure, will be getting updates out as things progress. So with all that being said on the ATDS issue, for companies that are using an ATDS or that are trying to determine whether they can or can't use an ATDS because they're just really trying to assess whether they have the right level of consent, I think it makes sense to kind of talk about the two different types of consent and how you can get those, or how you can assess whether you already have that. Next slide, Chris. So prior express consent, as we talked about, is the standard for a non-telemarketing call. So these are calls for debt collection. These are calls for some type of informational purpose, a survey call that has no sales component, those types of things. That term is not defined under the statute, nor is it defined in the FCC's regulations. Fortunately, though, the FCC and all the bad things that they've done over the years, the one thing that they did that was favorable was back in the early 90s, they held that providing your phone number to a business gives them prior express consent to make a non-marketing call to your cell phone, unless they indicate otherwise. So unless they limit how you can use it, or unless you yourself limit how you are going to use it when you collect that number. So pretty broad holding, really does allow us to have some good arguments for why we have consent to make a non-marketing call. Next slide. And that ruling has largely been upheld by the courts. Almost all the courts are deferring to the FCC based on the Hobbs Act, which I just talked about. There was one court back in 2013, the Southern District of Florida, that actually invalidated the FCC ruling, or tried to. They basically said that's more like implied consent. Somebody gives you their phone number, that's implied consent for you to call. It's not express consent, which is what's required under the statute. Fortunately, that case was overturned by the 11th Circuit. So again, just overwhelming body of law here really does support somebody gives you their phone number, that's consent. The only thing I would caution you is that you really need to look at the scope of consent that's provided based on how you're collecting the phone number. So courts and the FCC both are really trending in the direction of looking at why you're collecting the number, what you told the person it would be used for when you collected it, and whether the calls that are made are within the scope of that consent. So this Walgreens case that's on the slide here, they basically said that they were collecting phone numbers to verify a person's identity when they were picking up a prescription from the pharmacy. And they ultimately used it for other purposes, and they deemed that those calls were not made within the scope of consent that was provided. So you really want to just get phone numbers as a general contact number, really not place any type of limitations on why you're collecting the number, what it will be used for, so that you have very broad consent, and you could make these non-marketing calls using an ATDS or a pre-recorded message up until the point in time where somebody revokes that consent. So something to go back and take a look at. Now, I think there's kind of two takeaways. One is this whole concept of focusing on scope is bad, and that it's a little bit more difficult to apply. It's more difficult to determine whether you do or don't have consent. So that's certainly something to think about. But the kind of counter to that is the fact that we have to look at that and look at the scope of consent actually is good for people that have been or will be sued, because it really kind of requires more of an individualized look at how did that specific person provide their phone number and what was said and what wasn't said. And based on that, I think it's just going to be more difficult for plaintiffs to get a lawsuit certified as a class action, because you're looking at each person, and each person might have gone through a different set of circumstances in order to provide some type of consent. So interesting kind of double-edged sword there. Next slide. So with respect to written consent, we're getting lots of questions from people now. I think, starting in 2013, we started to get these, and then starting with the FCC's most recent declaratory ruling, we're kind of seeing a new wave of questions related to written consent, and is this sufficient, and how do I get it? So I thought it might be beneficial to just talk at a high level about some of the requirements, and then talk a little bit about how those might apply. And I know Ryan's got some slides later on to talk about best practices when obtaining consent, et cetera. So the core requirements are, it has to be an agreement in writing that includes the signature of the person, including an electronic signature. So you'd have some type of a written agreement with a signature. That can be an online agreement, that could be a paper agreement. As we'll talk about here in a minute about electronic signature, that could even be a recorded phone call. So that's the first requirement. Second is, it has to identify the specific seller to whom consent is being provided. This is typically an issue in the lead generation context. So a lead generator is trying to get consent for a broad range of companies. Maybe it doesn't know who it's going to sell the lead to. Maybe you're a company that's buying leads, and you're trying to make sure that the consent language used by that third party is sufficient. So there needs to be some type of identification of the seller or sellers that consent is being provided to. It has to include the phone number. I think that's pretty self-explanatory. You can't consent to be called unless you're specifying the number to which you're consenting. Affirmative action, there has to be some type of action that the consumer is taking. You can't rely on silence. You can't rely on inaction to be consent. The most common question I get here relates to pre-checked boxes for an online web form, and whether you can use a pre-checked box, or whether you can just use a submit button, for example, rather than having an unchecked box. So I think that that's a very dynamic issue, and something that really depends on the overall context of the form. I mean, if the form is, hey, fill this out, we'll give you a call, I think a submit button's fine. If the form is, I'm filling this out to place an order, I think that there's much more risk if you're not using an unchecked box there to get consent. If you're just trying to slap some disclosure language there and then have them submit to both provide consent and place an order, I think there's some risk there, and you might want to think about that. So really, you kind of need to look at those individually and assess whether or not the form is sufficient. Next slide. So the other requirements are that you have to have very specific mandatory disclosures. The FCC did not do us any favors when they defined what written consent is. So you need to disclose that it's a marketing call. You need to disclose the type of technology you're using to make the call, and you need to disclose that consent isn't required as a condition of purchase. So pretty ugly disclosure, something that I know a lot of business and marketing folks just really don't want to put in there, and understandably so. I just think that if you don't have them in there in some way, shape, or form, now there's some leeway in how we do that, but if you don't have them there, we're not meeting the technical definition of what is written consent. So there's some possible risk there. So the other thing is you need to keep your records for at least a minimum of 4 years from the date of the last call. You want to make sure that if you are sued, you can pull out these records of consent and prove that you had it. The burden is on the seller. Very important. Next slide. And you know, the other things to think about, the FCC does have a definition of what clear and conspicuous means. They define it as something that's likely to be seen and understood by a reasonable consumer, and separate and distinguishable from unrelated provisions. So bottom line, don't bury it in some type of lengthy document. You can't get consent in a privacy policy or online terms and conditions. You need to make sure it's really close to where they're giving you consent, whether they're signing, whether they're checking a box, whether they're clicking on a button, whatever it might be, it needs to be right there. And the other thing is electronic signatures, which we talked about a little bit, but the FCC specifically said in 2013 when it came out with the new rules that you can use you know, any type of electronic signature. So you could get consent via email, you could get consent over the phone via key press or voice recording. There's a lot of leeway, but again, you just need to make sure that you can prove it and that you have records to back up that consent. And then last, next slide, I just want to kind of remind everybody about how the FCC ruling impacts those types of consent. So number one, regardless of what type of consent you have, they can revoke consent. They can do that over the phone, they can do it in writing. They basically said they could do it any reasonable method and that you can't limit those methods. So you really need to make sure if you're relying on consent to make these calls, you need to make sure that you have good processes in place to not only get the consent, but then process a revocation of consent. So making sure that you're not making any more calls or sending texts to people after they revoke that consent. I mentioned earlier the written disclosure requirements for written consent. Some people had petitioned the FCC to ask them, if I already had written consent, do I really need to get it again with those disclosure requirements in there? And the FCC said yes, that type of consent is specifically required in another rule, and if you had gotten consent and you did not have those disclosures in there, that would not be sufficient. So they did provide some type of very limited waiver for certain people that obtained consent prior to 2013, but by and large, if you did get consent and you're not meeting the FCC requirements, you need to go back and make sure that you're getting additional consent before making calls to those people. So that's all I have for today. I'll turn it over to Ryan to talk about some best practices and ways to mitigate risk, and then happy to answer any questions at the end of the session as well.
Ryan?
Thanks, Nick. That was a great intro, and appreciate the groundwork, especially the update on the recent cases that have conveniently are located up here in Northern California. This is where we're based. I've been with contact center compliance going on 11 years. We've got a strong track record in supporting PACE and helping kind of our customers, not only on the data side, but just kind of get a handle on things with TCPA. I had some plans to kind of take some time off over the summer, which were conveniently interrupted by the new order. And we've just seen a real increase in not only questions, but just in terms of amount of scrubbing people are having to do to comply with TCPA. And so I've got some best practices I want to kind of share. I'm going to go to the next slide and just kind of give some people some tips that we've learned along the way. We also do some of our own compliance summits, and we've kind of gathered some good resources that I think have really helped people at least kind of put some plans in motion in terms of, okay, we kind of get a feel for what's in the order, we know what the high points are our legal saying we need to do X, Y, and Z, but what else can we do to kind of mitigate risk? And so I think the biggest thing is you really need to get consent from everybody you're talking to, and you need to get it in writing. You need to get it so that you can bring it up and also document that you're getting how you obtain the consent. There's a couple, I would say newer vendors, but people that I've met through PACE that they're in the lead capture business that have been, I think, benefited from some of the TCPA in the sense that they can provide some ways to actually show screen captures and processes of the way that the consent is being delivered so that there's no question that person did in fact provide consent. Because what we've seen from the litigant side, or the stories I've heard, is that just it's all over the map. You know, people will say that and by the way, if there's any professional litigators on the call, they can leave now. That's my disclaimer for the day. But basically, there's been almost trickery where won't fill out the forms correctly. They claim they revoke consent. They claim they never filed a consent. All kinds of things are happening with clients that I deal with that are getting TCPA claims. And so, you know, there's the couple vendors that I've heard out there. There's one that was at the PACE Summit Active Prospect. There's another one called Lead ID. But those are good options. Then when you're getting the consent, or at least whatever you're doing, make sure you can bring it up and reference it. Let's go to the next slide. Especially with your disclosures, you want to be very clear and concise, and you want to look for ways to eliminate risk, especially with class actions. Make sure that you're offering up maybe some sort of arbitration clause, which now, of course, the CFPB, I think last week, said that they have they're taking an aim at they're getting rid of those in agreements with customers. But you want to make sure that you can bring this up and that it's right out of the gate. Let's go to the next slide. So there's different ways to get consent. A lot of people obviously are working on the phone, and so getting oral consent is sometimes preferred. We work with a lot of online lead generators, so you know everybody claims. You hear this a lot in the industry that what we're calling opt-in leads. All we do is call opt-in leads, and you have to really kind of sometimes question some of these programs where you get a kind of maybe sometimes over-eager salesperson. What kind of opt-in? Is it TCPA opt-in, or they just express some interest and clicked on a button on a website? And so you really want to look at that, especially if you're getting campaigns as an outsourcer, to make sure that, especially when you're doing transactions that might incur a debt later down the line. We work with a lot of collections folks, and the problem they have is they get the debt, they don't know what kind of consent is there or was originated, or it wasn't enough when it comes to TCPA to actually put it through a dialer. And so making sure that you can get those, especially on mortgage and banking, financial services, which is also a big target for by the TCPA professional litigants, collections, financial services, the top 2 or 3 that I've seen out there. Let's go to the next slide. So these are the ways that you can get consent, obviously from different methodologies. Text messaging is also very popular. Replies to email and mail, I would say, are probably least popular. And then, you can make it kind of part of the sales process, which I've heard as a tip, or you can sometimes, to some degree, I've heard, incentivize the person to, if they give you consent, maybe give them a discount or something like that. But you really want to kind of look at how that's played out. Let's go to the next slide. So obviously you've got to comply with the e-Sign Act. You've got different options of how you're going to do checkboxes. You want to look at it from probably the most conservative standpoint. There's a lot of litigation out there. TCPA is not going to go away. I've heard that numbers are increasing in terms of number of litigants, repeat filings, and just overall clients that are contacting us and telling us that they've been targeted. And so you want to be able to back up that how you got the consent and that you do actually have a compliance vendor scrubbing program, especially when it comes to a couple areas that I'll get to in a second. Let's go to the next slide. I'm not going to go through all of these examples of consent, but they are actually kind of good because, especially when you're on the data side like us, you don't really see the day-to-day scripting things, and clients call us and want to know what needs to be in the consent language, and so we thought we'd kind of put these out there as resources that people can look at down below. But taking the language and then distilling it down to what works on the sales side, because you kind of got to balance the two between compliance and sales, so you can actually make money and not spend it all on your compliance program. Let's go to the next slide. That's a web form. There's a web sign-up one on here, which is good. Also making sure that when they're giving you consent, you can tie it to that particular phone number, and it's just not consent from an account holder. And then providing them the opt-out options too as well, so that they can get their preferences kind of distilled down. Let's go to the next slide. And again, on the telephone side, you really want to ask them what mobile number do you want to give as contact, or you can even ask them, what kind of phone is this? For some of my clients, what they're doing is when they're generating, let's say, inbound programs, they're screening for the type of call before the call even hits the agent. So if they know it's a mobile phone and they're going to have some follow-up activity, and their intent is to put it through a dialer, they're going to build in that consent at that point. Or the reverse side is true. When we work with a lot of our clients now, they're using us to scrub out litigants. So we have a way to identify phone numbers that have been used in litigation. I just got 4 new ones last night. They were called the worst of the worst, but they're screening for these people on inbound calls. So if it's flagged as a litigator, they may not even attempt to get permission. They may just try to back off the call and look it up in their CRM and figure out if there's another way that this person has some interaction. That's another way to kind of deal with people. But let's go on to the next slide. You've also got some signage, text messaging. People are surprised by TCPA how it impacts text messaging. I guess here in the Bay Area, it's not such a surprise because we have a lot of cases that are involved and come out here. But just overall, people think that text is more like email, but text is covered under TCPA. If you look at the TCPA cases, there's a huge archive of ones, and that's another area that's ripe for litigation, especially with folks just kind of being blindsided by it, just like Nick mentioned earlier, where you got other areas where people are surprised that TCPA covers, which is, got a big one coming up, political, collections, even follow activity where you originally didn't have the consent. Let's go on to the next slide. Let's go skip to the next one too. That's just an email example. I'm going to get into this part right here, because this has kind of got some interesting tips that we thought we'd share with folks. We want to get into the compliance readiness piece, the next one. Somebody put a goofy graphic in there. It wasn't me. So you really want to make sure you can get all the information. That there's not just, people are surprised that with the new order that there was already another order and subsequent background that really, because they're new in the industry. So you want to be able to go to events that can give you that information. You want to listen to webinars. You also want to make sure it applies to your business, because there's a lot of different types of calls and also folks that are impacted with it. So, whether you're a lead generator, you're an outsourcer, you're a seller, you're in insurance, you're in healthcare, there's certain real niches that have different elements to them. One thing people struggle with is what do we train our staff on with TCPA? Are we going to train the agents? Are we just dealing with compliance? What do we need? And we need to kind of what do we need to tell people about that? And as far as looking at, you got TCPA, you can kind of get blinders on, because there's still a lot of state rules that impact calling. There's even a few that states where you can't manually call cell phones, and they've got other auto dialer restrictions, special registration for dialer campaigns, or just overly aggressive towards automated calls and call center works. And we've got a couple kind of mini compliance seminars that we do coming up, one next week in Carlsbad, one down in Florida at the end of the year. We can get out some more information about that, but or you can go to our website. So if you want to skip to, yeah, this one right here. I mean, the FCC is pretty interesting as far as watching what's going to happen with the cases this next year. You've got several of them coming up, including Pace's own petition, but you also have the Gomez case, and then there's another one that's coming out that are actually going to be at the Supreme Court, so they're going to start to hear arguments on that that'll have some impact in terms of if you can offer up a settlement to moot the damages. I'm not a lawyer, so I'm going to try to summarize my understanding that you can kind of get around or suffice it enough where if you pay for what the actual damages are, they can't then claim a class action and go after further incremental damages, which is why TCPA is so dangerous. I had a customer about a month ago. They called us. They got served with a TCPA suit. Small B2B company. They're being sued by a pretty regular in the litigator circuit for $5 million. And this is a company that definitely was very surprised by the fact they were even under that umbrella. Got another customer that they got sued. They're actually a big trade union. They got sued for TCPA by one of their own union members. They outsourced some of their calling. Union member didn't really know he was suing his own union, which is kind of funny. But this guy was a professional consumer rights attorney, and so client wasn't using our litigator scrub, but it was actually on the list of phone numbers that we scrub out. So it's kind of interesting. If they had used it, they wouldn't have ran into this guy. So I think he's changed his heart after he found out he's suing his own union, which is kind of funny. Next slide. So you definitely want to make sure you have policies, procedures you can point to, just like do not call, just like other areas of compliance, so that you can really show, if you had to, that you took TCPA seriously. Next slide. So one of the things that's real difficult for companies to do right now is to deal with the wrong number part of the recent ruling, where you only get one pass. It's difficult to find a good resource to verify phone numbers, especially mobile phone numbers. So we've been working with some of our clients, and we've actually got a solution coming out where we're going to be doing phone verification specifically for TCPA, where you can basically take a list with a name and number, send it to us. Within 24 hours, we'll go in and verify and rank. We'll identify the disconnected numbers, then we'll also go in and identify those numbers that do match on a scoring system. So you can take your top scores and use that as a way to still put them into an ATDS, and knowing that that number still belongs to that person. And then also provide that backdrop if you ever get sued, that you had a process in place to verify numbers. So I know there's been a lot of questions about places to do that. We've got a way to do it, quick turnaround, and then we've got some really good pricing, so it's not quite as steep as you might think. Making sure that you have a good scrubbing process for cell phones. A lot of people either don't use a good vendor or have don't do it as frequently enough as they should, and so you run into issues where people leave data on the dialer too long. They won't scrub it every 15 days. You really want to be careful with your cell phone ID. And then then you have to look at a couple other areas that you might want to scrub out, which the litigant list that we have definitely prevents a lot of the calls or texts or overreaching type attorneys that are really kind of on an exponential nature. And then let's go on to the next slide. You might also want to look at other area, which is the idea of VoIP phones. There's been some cases about that, so we do scrubbing for VoIP as well, but that's another area you might want to be careful with. The litigators love getting phones that are part of this reassigned. They like numbers that are ported. There's a good chunk of them on Neustar's ported data, so just kind of watch out across the board. So, I mean, if you talk to an attorney like Nick, he's going to tell you to make sure, you're being pretty clear and concise on any kind of, opt-out programs in terms of providing that information, making sure that you don't overreach in terms of, you say you're going to get one text a month or one a week, don't go beyond that. And then especially with text campaigns, getting the double opt-in is preferred. Let's go to the next slide. So should say text Veggie burger because we're in California, but this is, I guess, one of the upsides to these one-off retail campaigns that kind of came out of it. So there's some silver lining in the new ruling. Not all doom and gloom. If you have a good process for the data side, for analyzing your business, consulting with a good compliance attorney that can help you figure out where you're exposed and what applies to your business, there's definitely still, it's not, the Armageddon's not coming quite yet. Go to the next slide. So, as far as training your employees, the scripting element is going to come into play, and then making sure you can document that training. We've got some training that we do for our clients on our application to help push this out and kind of knock it off the list. Let's go to the next slide. So I've heard this before from a lot of people, and it's actually kind of a good idea. You really want to look at where your complaints are coming in as far as an indicator of any potential problems before they spiral out of control. And you want to make sure that you're dealing with complaints in a timely manner. I mean, this is kind of business 101, but when it comes to things that are going to drive consumers to reach out to one of these litigators who advertise on TV at late at night or whatever, or pretty easily findable on the web, and one of them has even got an app, you can file the call details and complain about the call right on your mobile app, on your phone. If you can take some of these basic kind of feedback and mechanisms, you might not get the guy who wants to now complain because you called them at 5:02 p.m. and the calling time cut off is 5 or whatever it is. Let's go to the next slide. This one I have to look up every time. How long do you keep records for TCPA? My answer is usually as long as you need to or as long as you can, but they do have it as a 4-year rule. And then these tips are good as far as especially the opt-out side. A lot of people worry about the opt-in, but you also got to worry about the opt-out. And then the snapshots of information using some of these software or vendors to kind of help you along with that process, I think is a good idea. Let's go to the next. So yeah, making, kind of creating that culture of compliance is very, very helpful. Having a compliance officer, I've actually seen several companies I work with, they actually have either a TCPA compliance team or a TCPA compliance officer, which is all within the last 6-12 months, which I thought was interesting. Let's jump over to the next one. So this is the one I mentioned earlier, which really surprised me that the CFPB was trying to push this away, but I mean, I even heard this at PACE. It was something like, I think when the attorney said that arbitration clauses are your kind of best weapon against consumer class actions. And so you also got to worry about your terms and conditions. And you can also, FCC put some interesting language about how you can kind of help indemnify yourself and even potentially go after folks that you have an agreement with, which was interesting. Go to the next slide. And just some additional examples. Let's jump to I know we only have a short amount of time. This is another area that has really popped up, is the insurance coverage. So what's happened to a lot of my clients is they have gotten their policies and they're getting excluded from TCPA. So they had some sort of E&O or D&O insurance, and then all of a sudden now they have exemptions for privacy-related matters, and they're excluding TCPA. Or another one of my clients, they got accused of TCPA. The case was dismissed, but guess what? They had to disclose it to on their renewal if they've had any issues pertaining, and so now then they couldn't even get coverage from that, so you have to go somewhere else. And so you got to really look at those policies and see. And there are a couple of companies out there that do offer, if you can substantiate that you have good, track record, etc. Next slide. I'm going to turn it over to our friends over at ConnectFirst, Geoff Mina. We've been partners with ConnectFirst for a long time, and I know they've got some exciting information about some of their product design to help people deal with TCPA on the dialing front.
All right. Thanks a lot, Ryan and Nick. I wanted to take a couple minutes today to talk about the ConnectFirst Safe solution. Typically, I don't like to include product pitches in these webinars, but the demand was so high after part 1 that we're just going to take a few minutes to talk about how ConnectFirst can solve some of these complex technical problems for customers that use our technology. As Ryan said, so much of TCPA is around policy and procedure, but the ATDS piece is also really important. And having a technical solution that makes the implementation of your policies and procedures easier and more fault tolerant is a really critical piece to the puzzle. So I'm just going to briefly go over what we call our Safe Mode product, and it's a variation of the ConnectFirst Contact Center suite that was specifically designed around the TCPA legislation. We were the first to market, and we came out with this version of our product in September of 2013, about a month ahead of the initial ruling. Or the initial ruling's activation date, I should say. We approached the problem from a legal side first and foremost. We didn't just send a bunch of software engineers off to develop a compliant solution. We engaged 3 different legal teams to help us vet our proposed solution, and it wasn't until all 3 of them agreed and signed off on our architecture and our solution set that we started working on building the product. So we've had a lot of eyes on the solution. Nick and his group was one of those legal teams that helped us architect this, and they continue to advise us on any changes that we may need to make in an iterative fashion. So the most important piece that we try to focus on from our side is making sure that the product we provide is clearly outside of the definition of an ATDS. So that's completely separate infrastructure and systems and code base from any of our other products, which include a predictive dialer. There's no automation in the Safe Mode product. We've stripped out a lot of the features and functionalities in our predictive dialer that could constitute automation. So we've taken out all the answering machine detection, pre-recorded messages, any progressive dialing type of functionality, and the agents are required to manually initiate each call on a one-to-one basis. So we're very confident that the solution is clearly not automated in any sort of way. Additionally, we tried to retain all of the benefits and the pieces of the ConnectFirst suite that we could. So that's really powerful campaign and list management, our integration with contact center compliance on their DNC and cellular scrubbing product. It's all automated and built in. So when you upload your data, it strips out everything that you can't dial, only allows the right numbers into the system in the first place. You get your call scripting and your typical agent interface, and then all the reporting and analytics that come along with using a system like ConnectFirst and not actually doing manual paper dialing. So that's kind of from a technology standpoint. The other approach we took was the FCC didn't really do a good job of taking into account SaaS or cloud-based solutions. They always use this term equipment. And with a SaaS solution, you don't have equipment per se. Your equipment is a desktop PC and a web browser. So we felt it was really important, especially after this last update to the TCPA, to contractually protect our customers from the fact that they don't have access to the equipment and the ConnectFirst engineers do. So we've got really strong wording in all of our contracts with our customers that will never modify our safe mode product to be anything that could be considered an ATDS. So it's just the other side of the equation that we felt was important to address from a SaaS vendor standpoint. We've got one other really unique element in our solution, which is an end-to-end audit trail. And when you upload data into the ConnectFirst platform, we flag that record as being uploaded into a safe mode account. We track it all the way through the system as the number's dialed and connected to an agent, and even all the way out to the public telephone network. We indicate on the dial attempts that it was a manually initiated call. So we've gone to great lengths to create an audit trail that you could present to, that our customers could present to a legal counsel to prove that the call was a manually initiated call and had never been called in any other way. I can jump to the next slide. So we've always taken the stance that it's our responsibility to our customers to provide solutions that help them stay in compliance. We understand that we're a mission-critical infrastructure for all of our customers. So we've always tried to do everything in our power from the software and technology provider standpoint to help ensure that all the tools to implement your process and procedures are available. And the safe mode product is just another extension of that. So it looks like we've only got a couple minutes left and there are a lot of questions, so I'm going to hand it back to Chris to try to get a handful of these answered before we're out of time.
All right, thank you very much, Geoff. I appreciate it. Okay, so we're going to go ahead and get started. We'll get to as many questions as we possibly can here. So the first one I have, it says, if we have a database not connected to our VoIP phone system and we are manually copying and pasting numbers from our database into our VoIP soft phone, does that constitute a manual dial?
I think that's probably a little bit too specific to answer. Happy to answer that one maybe offline or provide some guidance, but that's so fact specific that we'd probably need a lot more details than that.
Okay. Then the next one is this. Is there any court holdings opining on whether, one, the required disclosures for prior express written consent can satisfy the clear and conspicuous standard if they are put in the website's terms and conditions as opposed to the opt-in landing page for the given marketing campaign? I'll let you answer that one before I go to the second part of that question.
Sure. So the actual prior express written consent requirements that took effect in 2013, there really hasn't been any case law at all addressing, specific language. This language is okay, this language is not, that type of thing. It's so new, and quite frankly, because a lot of these cases end up settling before they get to that point, there has been nothing from courts. What I can tell you is that the term clear and conspicuous has been addressed by the FTC, so a different agency, but one who routinely provides guidance on what is clear and conspicuous, and that I think the FCC would agree with, and courts are likely to agree with as well. They've given lots of guidance on what clear and conspicuous is, and they would deem anything in a privacy policy or terms and conditions to not meet that standard. So nothing specifically from courts yet on that, but I would caution people from trying to get consent in that manner because it's routinely been held by regulators that is not a clear and conspicuous disclosure, regardless of what it is.
Okay. And the second part of that question, Nick, is the use of the words "you consent to receive marketing text message" is a sufficient disclaimer to put the customer on notice that you will be using an ATDS to send the text.
So what was the first part of that? You consent to?
If you put the words "you consent to receive marketing text messages," that is sufficient disclaimer to put the customer on notice that you will be using an ATDS to send the text?
I would say no. I mean, there needs to be some type of disclosure about, I'm not saying you have to use the word automatic telephone dialing system, that phrase word for word, but I do think there needs to be something there about automated texts or something to that effect. You consent to receive automated texts regarding, blah, blah, blah.
I think you answered this next one. Okay. Please elaborate a bit on the recorded call for the written consent.
So the FCC specifically said that you can use a recorded call and have the person verbally agree to provide their electronic signature or press some type of button on their phone to provide their electronic signature. So the process is basically the same. You have to have scripting in place. It has to meet all of the consent requirements. It has to have all the required disclosures. You have to have the affirmative action, which would be their response or their pressing the button. You'd have to retain that for the entire length of time. So it's no different. I mean, there's some kind of interesting, I guess, back-end considerations for that. Number one, what happens if an agent doesn't read the script word for word, so they're not getting the disclosures in there, or what happens if the person doesn't actually affirmatively respond with a yes after you ask for consent? If they say no, is that a do not call request? So there's lots of different things and implementation issues that you might need to consider, but the actual concept is largely the same as other mediums.
Okay, the next question is in regards to outbound thank you calls. This person says, we place outbound calls to donors of our PBS clients to thank them for their donation when they called and donated a month or so prior. This person's a bit confused on how this is applied specifically for nonprofits, if that even matters.
So two different things there that ultimately get us to basically the same spot, which is it sounds like, and obviously scripting would be important, but it sounds like that's an informational call only. There's no solicitations involved. Therefore, if it's a call to a cell phone and you are using either a pre-recorded message or an ATDS, you just need prior consent. You don't need prior express written consent. So the standard is that if it's a call on behalf of a nonprofit, those are always subject to prior consent, regardless of what the purpose of the call is. If it's on behalf of a nonprofit, even if there's some type of solicitation involved, it's subject to prior express consent. So you just need to make sure that you're meeting those standards.
The next question is, if a call is recorded, can prior express written consent be obtained verbally?
Yes, meeting all those same requirements that we talked about.
Okay. Ryan, this one is for you. It says, does Ryan suggest including a no, I don't want to get calls option, and if so, why?
I think a lot of companies have adopted a kind of a preference. How do you want to be contacted? Maybe not, I don't want to receive calls, but maybe ask the customer, how do you want to be contacted? I mean, I see this as a consumer when I deal with some of the vendors that I deal with. So I think it's a good idea to find out, and then maybe not encourage do not call, but get an idea of are they going to respond better to text, email, what's their preference, and then like if you get into text, how often do you want to receive a text? So that's the way I would look at it. I'm a sales guy too, so.
Absolutely. I know we're a little bit over, but we'll do 3 more questions if that's okay. Do companies that don't own and ATDS need to be concerned with this ruling? Almost all phones have capacity to be hooked to a dialer, but if we don't own a dialer, does this ruling pertain?
Well, so that's kind of a loaded question. I mean, the question really becomes, what is a dialer, right? I mean, so depending on the type of phone it is, it may be completely outside the scope of an ATDS, and therefore you don't need to worry about the consent requirements. You would need to worry about do not call. You would need to worry about calling times and all those other things, I guess depending on the type of call, if it's marketing or non-marketing. But if it's a phone that could potentially be an ATDS under that vague standard, you'd really need to look at what's required to turn it into an ATDS. Is that sufficient to meet that potential ability standard? There's a lot of gray there. I can tell you that there's probably not a clear-cut answer, but certainly there could be a situation where somebody alleges that it is an ATDS, and you would have to defend that. So I would strongly consider proactively thinking about what your arguments are going to be and how you're going to prove that, rather than waiting to get sued and then try to figure it all out then.
Okay. This question is, can you provide information regarding a litigation scrub?
So yeah, we offer that as a scrub service. This is Ryan over at dnc.com, and we do it based on phone numbers, which is interesting. So we've got 85,000 numbers and growing of professional litigators. We get about 1,000 to 1,500 monthly, pulling it from case information, from different attorneys we work with, from our own clients, and it's pretty effective. Like I mentioned, that one story with the labor union. I mean, that guy was a professional. I mean, you see a lot of the same. If you actually look at the case filing, you'll see a lot of the same usual suspects pop up over and over again. And surprisingly, yeah, the phone numbers don't roll over as much as you think, and so our clients are using it to scrub it on outbound and even on some inbound campaigns. They really just kind of, ride this whole thing out so that, they're not being targeted for something. A lot of these clients I work with, they do a very good job at the rest of their scrubbing, but they're still getting targeted by these kind of mechanically engineered cases and dragged through the mud. And so definitely a good way to do something that helps get rid of the folks that have the app and whatnot. So definitely you can reach out to me and I can give you some more information on that.
And Geoff, the last question that we're going to take is for you. It says, can you do predictive dialing in any way with ConnectFirst? And if so, then how can you ensure your system does not have the capacity to auto dial in safe mode, given a programmer could configure it differently?
So that's a good question, and it's part of our technical solution in that the software code base that does the predictive dialing is completely separate from the software code base that we use for the safe mode product. We do have predictive dialer functionality, and the way a lot of our customers use our solution is that they'll take a list that maybe they don't know what's cell phones and what's landlines, and they'll upload it into their let's call it predictive dialer account. We then send that list off to Contact Center Compliance's DNC.com product, and it sends back a list that is, here's your numbers you can dial predictively, and here's your cell phones. And then the customer can take those cell phones and put them into their safe mode account. And the agents, it's completely different URLs, different logins, different agent accounts. So there's no crossover and there's no potential that a safe mode agent working on cell phones could accidentally put it into predictive dial mode, or even an administrator on the account could. And the fact that ConnectFirst is contractually bound to not modify the product to do any predictive dialing protects the customer from the things that are somewhat out of their control and in the control of ConnectFirst.
Perfect. All right. Well, again, everyone, I want to thank you all for attending today's webinar, and a special thanks to Nick, Ryan, and Geoff for their information and insights that they provided us today. I would like to remind you all to attend the 2016 PACE National Convention and Expo that's being held April 3rd through the 6th at the Rosen Shingle Creek in Orlando, Florida. The early bird registration will be open soon, and you will then be able to find out all the details of the event on the PACE website, which is www.paceassociation.com. Thank you all for attending today, and have a great rest of the day.